national trial attorney Michael Jaafar to see what he thinks about this case. Michael, I know you follow the Karen Read case very closely. You didn't have a lot of good things to say about this defense, but tell me just what you think about the possibility that there was an actual invoice between the expert that was so great for the defense and the Karen Read team.
Massive, massive. This is completely massive. I know full well, deep down in my heart, that Karen Read's story is made up. So this defense expert was the biggest point of the defense case. They only took the case for 2 days after, I think, 28 days of testimony for the state, I think roughly in that area, right? And I remember this defense expert coming on and saying, there's just no way that the injuries from getting hit by the car would cause him to die. And then on cross-examination, he changed his mind, said, I guess it is possible if he fell back and hit the curb. And the whole entire overlay of the entire testimony was that he was independent, and how big of a deal it was that he was independent. I still believe that their case, that the defense, did not perform on their promises of shocking us and amazing us. But I was a little bit stumped by the fact that an independent expert for the federal government was testifying for the defense, and now we know that he issued an invoice. Look, Julia, from where I come from, if you issue an invoice, you're not independent. I don't care what you say. I don't care what your title says. But also, this had a strong impact on the jury. What else would have had an impact on the jury, right? It was an independent expert by the government that came in and testified and said, I don't think that she would have died, John O'Keefe would have died from these injuries. And now the body language of the judge, by the way, my stomach turned when I saw her body language. I've been in courtrooms when judges have taken me to the woodshed. It's not a good feeling, but it was never on a national spotlight. This is a national spotlight. Those defense attorneys would have been absolutely stunned. I can't even say the words on TV of what they would have been feeling based on her body language. This judge has been eminently reasonable to the defense. She's given them everything they've wanted. She's been more than fair. She's definitely been an amazing judge. Right? She's called balls and strikes the entire time. She's been in the hot tank the entire case. And this defense, for them to see that body language from that judge, I'm telling you, this is massive. This is a massive, massive shakeup in the case. I would not even be shocked if we see a delay of the trial starting on April 1st. I would be stunned if we did, but it would not be completely out of the realm of possibility based on her body language. We got to see what she had, but the government sent her a direct letter while she was on the bench that caused her to stop a hearing in its midst. It's insane. And by the way, if in fact they did get an invoice, ethically speaking, I believe they have problems. They are required to disclose it. For the judge to find that out by herself, it's absolutely massive. I cannot understate the significance of it. I'm riveted to see how this plays out next week.
You could see her body language for sure. It seemed like her hand was shaking a bit. She was out of breath, and she didn't want to go forward. She wanted to make sure she gives these parties a week to be able to speak for themselves. Our Matt Johnson is following this case closely. He can give us all the details and the comparison of this to what we saw in the trial, what we heard about those experts. So that's ahead. Michael Jaafar, stand by. We do have to get to that break. All right, that's an objection where they are actually going to have to clear out the jury. Let's bring back in national trial attorney Michael Jaafar. Michael, I'm happy to be able to get your thoughts on where this trial has gone, because we have the defense wanting to bring in the claim of defense of others. There's been some very difficult details, information that's come out of this part of the trial, because the defense has said outside the presence of the jury, and it's on the record from other officials, a guardian ad litem for this child, that this mother allegedly was involved with the creation of child pornography that included her daughter. I mean, it's sickening to think about. And the judge isn't going to allow the jury to know anything about it. Your thoughts on whether or not Zachary Hughes should be able to talk about what was allegedly his motive for this killing?
1000% yes. I think it should have been admitted already. I think that this child was being used by her mother as some sort of a business venture, right? And I also thought that when the guardian ad litem testified, the way she testified, I think she opened the door to allow that in. First of all, I think it should have been let in from the beginning of the trial. Once it wasn't let in, when the guardian ad litem said that she had a great home, she was raised well, she opened the door for the defense. I thought surely the judge is going to allow it now, and the judge didn't allow it, which I thought was a gross mistake. Now it makes sense when they want to present the defense of others, I think, and he has to testify. Now the whole picture is laid out, right? The whole murder was macabre. She was stabbed multiple times, dozens of times. There was rose petals around her. Here's a Juilliard-trained pianist. His fingerprints are all over the door. His forensic DNA is all over the crime scene. And now he wants to testify, and they want to introduce this defense. Julia, 1,000. I think if the judge doesn't allow it when Zachary Hughes testifies, I think this is like complete. It's going to come back in a boomerang from the appeals court.
Yeah, let's listen to the judge. Let's listen to the judge and what he actually said, Michael, as to why he was not letting it in. Michael Jaafar, the judge says it's not relevant and it confuses the issues for this jury.
The question is not whether or not it's relevant, it's whether or not the relevancy of it outweighs the prejudicial nature of it. And so it's definitely relevant. And definitely when Zachary Hughes testifies, not only is it relevant, it's the entire case. What if this completely negates his murderous intent, right? This completely negates premeditation. If what we think is going to happen actually happens, which is Zachary Hughes going to testify and say, I was defending this young girl, not only is this relevant, it's the entire case. It's like saying that blood is not relevant at that point. Like it's the entire case. So I completely disagree with the judge. I guess I could agree with the judge that it wasn't relevant before the trial started, but by this point, and with the door being opened by the guardian ad litem, it was open and it did become relevant, and they did open the door to it, but the judge still balked and said it's still not going to be admissible. But if Zachary Hughes testifies, it's the entire, what's he going to testify for? Why did I commit this murder? Here's the why. I know I did it, but here's why I did it. And it was not premeditated. It was a heat of passion. I was defending a person. You know, maybe this was a manslaughter, voluntary manslaughter. This becomes uber relevant. It's the entire case when Zachary Hughes testifies. Now I know why they dubbed this the trial of the century in South Carolina, because this is a completely macabre situation. I can't even understand it from how bizarre it is.